Since 1990, at least 18 civil wars have been significantly fueled by exploiting natural resources.
Wow. 18.
Yeah, it makes you think, doesn't it?
Yeah.
The very things that, sustain life can actually become drivers of conflict.
Absolutely. And it's fascinating because when we talk about war, the human cost is obviously paramount, right? That's what comes to mind first.
Of course.
But the environmental side, it's deeply intertwined. It's not just collateral damage. It often directly impacts the survival of those same communities. We're talking poisoned water, destroyed farmland, things with really long-term consequences.
Exactly. It's this whole complex relationship, this web between armed conflict and protecting the environment. And that's what we're really digging into today. We've got this great source material, a joint report from UNEP and the Environmental Law Institute, top legal experts involved.
Yeah, it's a really thorough piece of work. It lays out this quite intricate landscape of laws that potentially apply.
Right. So we're looking at things like international humanitarian law, the rules of war, essentially.
Yep, IHL. And also international criminal law holding individuals accountable.
And then there's international environmental law itself, all those treaties aimed at protecting the planet.
Exactly. A whole raft of agreements.
So you hear all that and you think, okay, sounds like there are protections in place, problem solved.
Well, you'd think so. But the reality, especially when a conflict actually breaks out, is it's much murkier. These laws exist, but making them work effectively, that's the challenge.
That's the core issue.
Precisely. And that's our mission for this deep dive, really. We want to unpack what legal protections should be there for the environment in wartime.
Understand the roadblocks, the things stopping them from working.
Yeah, identify those challenges, and then maybe explore some ways forward, how things could potentially be strengthened.
Okay, sounds good. So where do we start? International humanitarian law, IHL. That seems like the foundation.
Yeah, let's start there. The report focuses quite a bit on Additional Protocol I to the Geneva Conventions, specifically Articles 35 and 55.
Right, from 1977. What was the big deal with those articles?
They were pretty groundbreaking at the time because they were among the first to explicitly try and protect the natural environment itself during conflict. Article 35 forbids methods of warfare expected to cause. Here's the key phrase: widespread, long-term, and severe damage to the environment.
Okay, widespread, long-term, and severe. Sounds comprehensive.
It does. Article 55 reinforces that, protecting the environment in the context of civilian objects.
But, I sense a but coming. The report flags this as a major hurdle, right? Calls it a triple cumulative standard.
Exactly, and they say it's nearly impossible to achieve.
Why? What makes that standard so difficult to meet in reality?
Well, the problem is defining those terms: widespread, long-term, and severe. They aren't clearly defined in the protocol.
Oh, okay. Ambiguity.
Right, so to prove a violation, you have to show the damage meets all three criteria. How widespread is widespread, how long is long-term, especially right after a conflict, what counts as severe damage. It's just really, really hard to prove conclusively.
So the bar is set incredibly high. You almost need an environmental catastrophe before the law even kicks in.
That's the practical effect, yeah. It limits its applicability significantly.
Now, what about EN Mode, the Environmental Modification Convention? That came even earlier, didn't it?
Yeah.
Prompted partly by Vietnam.
Yes, 1976. ENMD was different, though. Its focus was specifically on preventing the hostile use of environmental modification techniques as weapons.
Like trying to cause earthquakes or change the weather, that kind of thing.
Exactly, those extreme geophysical warfare scenarios. And the report notes it's generally seen as fairly successful because we haven't really seen widespread attempts at that kind of thing since it was adopted. It likely acted as a deterrent.
Okay, so it's success, but in a very specific niche. It wasn't really about protecting the environment from conventional warfare damage, was it?
No, not directly. That's where additional protocol isn't to come in, protecting the environment per se.
Right. And then there's the CCW, the Convention on Certain Conventional Weapons, and it's Protocol 3 on incendiary weapons. Do they help?
They touch on it, yes. But again, they have limitations, like requiring a very high threshold of environmental damage to be triggered, and they apply only in specific situations.
Okay, so limitations there too. And here's something the report really stresses. Most of these IHL rules were designed thinking about international armed conflicts, wars between countries.
And that's a huge issue because
most conflicts today are non-international, right?
Yeah.
Civil wars, internal conflict.
Exactly. And the report argues there's a kind of legal vacuum in those situations. The rules aren't as clear or comprehensive for internal conflicts.
So things like say rebels looting diamonds or timber to fund their fight, or granting logging concessions. There aren't strong international rules to stop that within IHL for civil wars.
Not really well-established mechanisms, no. It's a major gap. Natural resources often become the economic engine of these internal conflicts. They fund the fighting, prolong it, and the exploitation itself causes massive environmental harm. But IHL struggles to directly address that dynamic within a single state.
Right, the conflict minerals issue,
Yeah.
essentially. Okay, so the direct protections under IHL seem, well, maybe not as robust in practice as they sound on paper. What about indirect protections? Does IHL help the environment in other ways?
It can, yes, through fundamental principles that aren't environment-specific but have environmental implications.
Like,
Like the principle of distinction, the absolute core rule that you must distinguish between combatants and civilians and between military objectives and civilian objects.
okay, in a national park or a protected wetland, that would normally be a civilian object, wouldn't it? So you can't target it.
Generally, yes, but it gets complicated with dual-use objects.
Ah, right. Things used by both civilians and the military.
Exactly. Think of a hydroelectric dam or a power plant. It might supply power to a military base, but also to civilian homes. Attacking it might offer a military advantage, but cause huge downstream environmental effects or civilian hardship. It becomes a complex calculation.
That balancing act, again, what about proportionality? The idea that the harm caused shouldn't be excessive compared to the military advantage gained.
That's another key principle, and yes, it absolutely could apply to environmental damage. The report mentions experts suggesting the massive oil fires and spills in the first Gulf War might potentially have been disproportionate.
So commanders are supposed to weigh environmental harm in that calculation.
They should, yes, along with civilian casualties and damage to civilian objects. Then there's the principle of humanity prohibiting unnecessary suffering.
How does that connect to the environment?
Well, if environmental damage deliberately targets civilian survival poisoning water wells, destroying essential farmland that could arguably constitute unnecessary suffering, this links to something called the Martens Clause. It's a sort of safety net in IHL, saying that even if there isn't a specific treaty rule, conduct should still be guided by the laws of humanity and dictates of public conscience.
Okay.
And interestingly, there's a proposal mentioned by the IUCN for a sort of Martens Clause for environmental protection, explicitly bringing environmental ethics into that fundamental baseline.
That's a really interesting idea, sort of hardwiring environmental concern into the basic rules.
Yeah. And finally, under indirect protections, you have treaties that ban or limit certain weapons.
Like chemical or biological weapons.
Billy landmines.
Exactly.
Yeah.
Chemical weapons, biological weapons, anti-personnel mines, cluster munitions. These often have devastating and long-lasting environmental impacts. So banning or restricting them indirectly protects the environment.
Okay. And also rules protecting specific places, like cultural heritage sites or dams and nuclear power plants. Yes. Protections for works and installations containing dangerous forces. Dams, dikes, nuclear power stations. Attacking them could release forces causing massive destruction. Though, as the report points out, oil refineries and storage facilities are notably not included in that specific protection.
Right, which seems like a significant omission given the environmental damage we've seen from targeting oil infrastructure.
It is a gap, yes.
Okay, so IHL offers some direct but tricky protections and several indirect ones through general principles and weapon limitations. Now let's shift gears to international criminal law. Can someone actually end up in the dock at, say, the International Criminal Court for Environmental Destruction during war?
Yes, potentially. But again, it's not straightforward. The Rome Statute, which established the ICC, allows for environmental damage to be prosecuted, but usually as part of other crimes.
So linked to war crimes, crimes against humanity, or genocide.
Primarily, yes. For example, widespread destruction of property can be a war crime. If that property includes vital environmental resources like forests or farmland, the environmental destruction becomes the evidence or the method of the war crime.
I see. It's the underlying act.
Exactly. Or if destroying the environment is part of a widespread or systematic attack against a civilian population, like forcibly displacing people by destroying their land and water sources, that could be prosecuted as a crime against humanity.
Okay. But is there any crime that specifically targets environmental destruction itself in the Rome Statute?
There is one, Article 824. It explicitly makes it a war crime to intentionally launch an attack knowing it will cause, wait for it,
Let me guess. Widespread, long-term, and severe damage to the natural environment.
You got it, that exact phrase again. But it adds two more tests. The damage must be clearly excessive in relation to the expected concrete and direct overall military advantage.
Wow. So the same high threshold, plus proportionality and military necessity tests baked in.
Precisely. And crucially, like some of the IHL provisions, this specific crime currently applies only in international armed conflicts, not civil wars.
Another gap for internal conflicts.
Yes. And proving the intent that the attacker knew the attack would cause such extensive damage and that it would be clearly excessive is also very challenging. So, while it exists on paper, successful prosecutions under this specific article are likely to be rare.
The report uses the Darfur situation, specifically the arrest warrant application for President al-Bashir, as a case study here, doesn't it? Relating to water sources.
It does. The ICC prosecutor argued that deliberately destroying or poisoning water wells and pumps, vital for survival in Darfur, was part of a genocidal policy against specific ethnic groups, the Fur, Masalit, and Zagawa.
So the environmental destruction ruining water sources was argued as an underlying act of genocide.
That was the argument, yes. Depriving them of means essential to survival.
And how did the court rule on that specific point?
Well, the pretrial chamber, in the initial arrest warrant decision, didn't find sufficient evidence at that stage to conclude that water source destruction was carried out with the specific intent to commit genocide. They dismissed that particular aspect of the genocide charge initially. But significantly, one judge, Judge Uzaka, dissented strongly. She argued that systematically destroying essential means of survival like water and food in such a harsh environment should be considered a genocidal act.
So it really highlights the complexity in the legal debate around proving that specific genocidal intent linked to environmental acts.
Absolutely. It shows how tough these cases can be.
The report also mentions political tools, like UN Security Council sanctions, focused on conflict resources.
Yes, that's another angle. The Security Council can impose sanctions like asset freezes or travel bans under Chapter 7 of the UN Charter if it determines that the illegal trade in natural resources, like diamonds or timber, is fueling a conflict and threatening international peace.
So cutting off the money supply that comes from exploiting the environment.
Essentially, yes. It's about putting pressure on those involved, defining what counts as a conflict resource, triggering sanctions, and then actually monitoring and enforcing them effectively. Those are big challenges, but it's an important political tool alongside the legal ones.
Okay, so we've covered IHL and criminal law. What about international environmental law? All those treaties about biodiversity, pollution, oceans, do they just get put on hold when a war starts?
That used to be the prevailing view, perhaps, that IHL basically took over in wartime. But the report emphasizes a growing consensus now that actually international environmental law continues to apply during armed conflict.
Really? So those peacetime environmental treaties don't just switch off?
Not automatically, no. The thinking has evolved. Unless a specific treaty says otherwise, or its application becomes impossible due to the conflict, the general view now is that the obligations remain.
That feels like a pretty significant shift. How do lawyers figure out which environmental laws keep applying? The report mentions classification theory and intention theory.
Right. These are two approaches. Classification theory, groups, treaties. For example, treaties that set up broad international regimes like the UN Convention on the Law of the Sea, UNCLOS, or those protecting the global commons like the atmosphere, are often seen as continuing because they serve the whole international community. They're sort of like human rights laws in that respect, fundamental protections.
Okay, so based on the type of treaty.
Yeah.
And intention theory.
That's more case by case. You look at the specific treaty, the Multilateral Environmental Agreement, or MEA, and try to figure out if the countries that created it intended for it to keep applying even during a conflict. You look at the text, the context, the overall purpose.
So no single answer. You have to examine each agreement. Can you give some examples of how this plays out with specific environmental treaties?
Yeah.
Like for the oceans and CLOs?
Sure. NCLS has loads of rules on protecting the marine environment. But as we mentioned earlier indirectly, it has Article 236, the warship exemption.
Ah, yes. Exempting state ships on government non-commercial service.
Right. Though it still says they should comply so far as is reasonable and practicable. Other marine treaties like MARPOL often have similar exemptions. But interestingly, the report notes the Cartagena Convention for the Caribbean didn't originally have that blanket warship exemption.
What about protecting nature on land? Biodiversity habitats, things like the Ramsar Convention on Wetlands or the World Heritage Convention.
Ramsar doesn't explicitly mention armed conflict, but it does allow countries to change wetland boundaries for urgent national interests, which some interpret as hinting it remains relevant during emergencies like war.
Okay, a subtle clue, perhaps.
The World Heritage Convention is much clearer. It specifically lists outbreak or threat of armed conflict as a reason to put a site on the list of World Heritage in danger. That clearly shows it's meant to apply.
So the conflict itself triggers specific actions under the convention.
Exactly. And Article 6.3 is key. It prohibits states from deliberately damaging heritage sites in other states party to the convention. UNESCO even has projects, like one in the DRC, trying to use the convention to protect sites affected by conflict.
That's encouraging. Are there other notable examples?
Yes, the report highlights the revised African Convention on the Conservation of Nature and Natural Resources from 2003. It's quite remarkable because it actually includes explicit rules for armed conflict, requiring states to take measures to protect the environment during war.
Wow, that's very direct.
It is. And other conventions could be relevant too, depending on the conflict, like the London Convention on Dumping Waste at Sea, treaties on international rivers, or even agreements on transboundary air pollution.
And what about soft law? Things like the Rio Declaration or the World Charter for Nature. They aren't binding treaties, but do they matter?
They do. While not legally binding in the same way as treaties, these declarations and principles reflect a growing international understanding and consensus. Principle 24 of the Rio Declaration, for instance, explicitly states warfare is inherently destructive of sustainable development and calls for respect for international law, providing protection for the environment in times of armed conflict.
So they shape expectations and can contribute to the development of customary international law over time.
Precisely. They influence how states and courts think about these issues. The International Court of Justice has even referenced some of these declarations in its rulings, like in the Nuclear Weapons Advisory Opinion.
Okay, so environmental law remains relevant. Now, how does human rights law fit into this picture? It seems obvious that environmental damage in war must impact people's rights.
Absolutely fundamental connection. Destroying the environment during conflict can directly violate basic human rights, the right to life if water is poisoned, the right to health from pollution or lack of sanitation, the right to food and an adequate standard of living if farmland is destroyed.
And are there specific human rights instruments that address this?
Many are relevant. The Universal Declaration of Human Rights, core treaties like the Covenant on Economic, Social, and Cultural Rights. Regional systems, too, the report cites the African Charter on Human and People's Rights, especially the famous Ogoni Land case.
Ah, the case in Nigeria involving oil pollution and conflict.
Yes, where the African Commission found that the environmental degradation violated the Ogoni people's rights to health, property, and a satisfactory environment. It was a landmark decision linking environment and human rights.
So there's strong precedent there.
Definitely. And the European Court of Human Rights has also dealt with cases linking pollution to violations of the right to private and family life. Plus, more and more countries are recognizing a right to a healthy environment in their national constitutions.
It really drives home that protecting the environment isn't separate from protecting people. They're intrinsically linked. Okay, so we have this whole complex tapestry of laws, IHL, criminal law, environmental law, human rights law, all potentially offering some protection. Yet, the report's overall finding seems to be that, in practice, implementation and enforcement are, well, weak.
That's the crux of it, unfortunately. Despite all these legal avenues, holding actors accountable for environmental damage during conflict has proven very difficult.
Is there any example where it did work?
The main positive example often cited is the aftermath of the First Gulf War. Iraq was held liable for environmental damage like the oil spills and fires.
How did that happen?
Crucially, the UN Security Council set up a specific body, the UN Compensation Commission, UNCC, precisely to handle claims against Iraq, including environmental claims.
Ah, so a dedicated mechanism was created for that specific situation.
Exactly, and that commission awarded significant compensation for environmental damage, but it remains a fairly unique case. It highlights that without such specific, dedicated international mechanisms for monitoring, investigating, and processing claims, enforcement is often lacking.
So a major barrier is the lack of standing international bodies focused specifically on environmental accountability in conflict.
That seems to be a key finding. There's no permanent environmental court for wartime damages, and existing bodies like the ICC face high thresholds and jurisdictional limits, as we discussed.
Which leads us naturally to the recommendations. If the current system has weaknesses, what does the report suggest to fix it? How can we strengthen protection?
Several key ideas come through. First, tackling that ambiguity in IHL. There's a strong call to clarify the definitions of widespread, long-term, and severe damage in Additional Protocol 1.
Make it clear what the threshold actually is.
Yes. The report suggests maybe looking at the definitions used in the INMO Convention as a possible starting point. Getting clearer definitions is seen as essential for actually applying the law.
Makes sense. Clear rules are easier to enforce. What else?
A big emphasis on the national level. Countries need to incorporate these international rules into their own domestic laws and military manuals, and build up the capacity, the expertise within their own legal systems to investigate and prosecute environmental war crimes.
So domestic enforcement alongside international efforts.
Exactly. Then, focusing on those conflict resources again, the report recommends the UN works on a clearer definition of what constitutes a conflict resource, sets clearer triggers for sanctions, and really beefs up the monitoring and enforcement of those sanctions.
Trying to choke off the economic incentives for environmental destruction during conflict.
Right. And then there's a really interesting, quite innovative proposal.
Go on.
The idea of creating a new legal instrument specifically for protecting certain places. Designating critical natural resource sites or ecologically vital areas as protected zones, maybe even demilitarized zones, from the start of a conflict.
Well, like setting up internationally recognized environmental safe zones that are off limits to military activity.
Something like that. Proactively shielding the most important ecosystems, water sources, or agricultural areas. It's a forward-thinking idea for place-based protection.
That could be huge. Any other key recommendations?
Yes, addressing the issue of resource concessions granted during a conflict. The report stresses the need to review these deals in the post-conflict period, as they're often illegitimate and can sow the seeds for future problems.
Checking the legality and fairness of deals made under duress or by illegitimate authorities.
And finally, a call for more transparency and attention, suggesting an annual UN General Assembly report specifically on the environmental impacts of armed conflicts worldwide.
To keep the issue on the global agenda and track progress.
Exactly, to raise awareness and maintain focus.
Okay, that's a lot to take in. We've gone from the laws that exist, their gaps, like that incredibly high, widespread, long-term severe threshold,
Which is so hard to meet in practice.
to the potential for prosecution under criminal law, the ongoing relevance of environmental treaties, the human rights link,
And the real-world enforcement challenges, definitely.
and ending with these concrete ideas for strengthening protection, clearer rules, better enforcement, tackling conflict resources, and even these potential demilitarized nature zones.
It's a complex picture, but there are pathways forward being proposed.
You know, the thing that really stands out to me is just how difficult it seems to actually hold someone accountable specifically for environmental war crimes under the current rules. That high IHL threshold, the specific intent needed for the Rhone Statute crime, it feels like a major loophole in practice.
It is a significant challenge, no doubt about it.
Or that idea of demilitarized zones for nature. Imagine if that became standard practice. What a shift that would be, recognizing certain ecosystems as simply off-limits, even in war.
It would be transformative. And it connects back to this core idea. You, the listener, might often think of environmentalism as separate from peace and security issues.
Yeah, they often feel like different categories.
But this whole discussion shows they are deeply, fundamentally linked. Protecting the environment is part of building sustainable peace. Destroying the environment often fuels conflict and certainly hinders recovery. You can't really separate them.
That's a crucial takeaway. Environmental security is human security.
So if you found this interesting and want to know more, definitely check out the source report from UNEP and the Environmental Law Institute. It's dense but fascinating. These organizations are really at the forefront.
And it prompts some deeper thinking, doesn't it? About the responsibilities we have, states, individuals, not just to avoid harming people directly in war, but also to protect the environment that sustains us all.
It really does. It forces us to consider the long-term consequences of our actions, even amidst the chaos of conflict.
So maybe the final question to leave you with is this. Is the environment just doomed to be a silent casualty whenever conflict breaks out? Or can we find ways to give it a stronger voice, to make its protection a real, enforceable part of the laws of war and the work of building peace?
Something definitely worth pondering.
Thanks for joining us on this deep dive.